The key issue in dealing with extrinsic evidence generally regards its admissibility, and this usually pertains to a specific type of extrinsic evidence, preliminary negotiations. One party argues that the two parties had discussed something that was never written down in the final contract, and the court has to decide whether they're going to admit this evidence, usually of preliminary negotiations, or whether the parole evidence rule bars it. The parole evidence rule is a two-step process, and the first thing we do is determine the nature of the writing, whether the writing is integrated. And the parole evidence rule, shown in Restatement 209, 210, 212, and elsewhere, discusses whether the contract is integrated, meaning it is final and binding, but not necessarily complete, meaning there could be additional terms that were not included, but the terms that are here are final. Or that it is totally integrated, meaning it's the complete and exclusive statement of the parties as pertaining to this subject matter. And so defining the contract as integrated, and under that either partially or totally integrated, is the first step in knowing how the parole evidence rule will impact the admission of extrinsic evidence. How do we determine whether or not a contract is integrated? Well, one thing to do is read the contract. And similar to our discussion of extrinsic evidence, courts that take an objective approach will generally stop if the contract is clear and unequivocal, mainly if it has an integration clause. If a contract has an integration or a merger clause, courts that take an objective approach, which includes the case of United Auto Workers, as well as the approach taken in Pennsylvania courts, if a court takes such an objective approach and there is a clear and unequivocal merger clause, the court will stop there and determine the contract is completely integrated. There's a more middle ground approach, aptly from Middletown Concrete Products case, and the middle ground approach holds that the court can be skeptical of integration clauses in certain cases. They are usually binding, but there are grounds for skepticism in some cases, and therefore courts will sometimes admit extrinsic evidence as a preliminary step to determine if the merger clause is effective and binding. And some courts take a full-blown subjective approach. In Sierra Diesel versus Burroughs Corporation, we saw a full-blown subjective approach where a court refused to look at the unequivocal merger clause and instead took testimony that the parties did not really intend to enter into a final and binding agreement, showing that some courts will hear extrinsic evidence, at least with regards to the validity of a merger clause, regardless of what the contract says. But as a reminder, in Pennsylvania, we take a more objective approach. The Gianni case held that if a contract appears to be complete within itself, it is presumed to be the whole engagement of the parties, and accord with McGuire versus Schneider. Once we have determined the nature of the contract, we then look at the nature of the evidence presented to determine whether that evidence can come into court. In sections 213, 214, 215, and 216 of the Restatement of Contracts, we talk about the effect of the adoption of a writing, now that we have understood the nature of said writing. If there is an integrated writing, what effect does it have? Does it bar extrinsic evidence? Well, that depends on what the extrinsic evidence is introduced to show. And for this, I have a chart, which I hope is helpful, indicating that if the contract is a draft, of course, any extrinsic evidence can come in because we're not actually looking at a final document. If the document is final but not necessarily complete, then we will bar evidence that modifies an existing term, but since the contract is not complete, of course we can add a term, so long as it doesn't modify, change an existing term. If the contract is complete and exclusive, then we neither modify nor add a term through extrinsic evidence. There are some exceptions if we're, instead of trying to modify the contract, we're really addressing an issue of defective formation, showing the contract never existed, or a subsequent modification, which are always permitted, provided new consideration, or to explain a term, which is different than modifying or adding a term, or if we determine those terms are collateral, they are not part and parcel of this agreement, then the parole evidence rule does not apply to bar them.